Hello and welcome to the latest Mander Hadley podcast, where we explore legal issues that affect everyday life. Today, we're looking at the growing backlog in the family court system and what that means for parents and children in real terms. Over recent years, the family court has been under sustained pressure. Listings are tight, sitting days are being cancelled, and there is a shortage of judicial time. I'll start that again. Hello and welcome to the Mander Hadley podcast, where we explore legal issues that affect everyday life. Today, we're looking at the growing backlog in the family court system and what that means for parents and children in real terms. Over recent years, the family court has been under sustained pressure. Listings are tight, sitting days are being cancelled, and there is a shortage of judicial time in many courts. Cases that have been timetabled for months can be pulled a few days before the hearing because no judge is available. Others are moved to a different town at short order or switched to remote hearings with little time to prepare. The good news is there are practical ways to avoid the worst delays. Alternative dispute resolution, or ADR, can help many families reach outcomes faster and with less stress. To explain the court backlog and look at these options, I'm joined today by Stuart Daniel, Head of Family Law at Mander Hadley. So Stuart, hello. So Stuart, what are the main consequences of the family court backlog for families?
I think the main one, Tom, is the anxiety that's caused the parties going through this. Once proceedings are issued, they're typically waiting months for a first court hearing. That's deliberate because they need to get various documents prepared by that time. But once they get to that stage, if it's adjourned, it's going to result in more anxiety, more stress, more uncertainty. Practical issues present, time off work can be difficult, arranging childcare, the financial cost of further adjournments and such like. So those are the main consequences. It's the stress to parties and the actual financial cost of this as well.
So what's driving the delays in the courts?
I think the main issue, Tom, is the increase in litigants in person coming before the courts, and by that I mean unrepresented parties. Years ago when I started out, legal aid was widely available for family cases and civil cases. Even if people were working and had assets, they could generally get some form of support, which meant people could come to court with solicitors or barristers. That's now largely changed. When I go to court, it is very common to see people unrepresented. They haven't got the experience of the court system, and that's really causing the delays. It means that cases get adjourned because papers haven't been provided properly. It may mean that judges are taking more time to explain things to parties, which means hearings listed for 30 minutes take 2 hours. It's those sorts of issues, really.
Got you. So if court isn't the right option for everyone, or there's delays that are happening regularly, why should families consider something like alternative dispute resolution now?
Well, first point is it's now mandatory. So certainly for family law cases, before parties litigate and go down the court route, you have to, as a mandatory requirement, investigate ADR, alternative dispute resolution. Mediation is the favourite option from the court's perspective. And if people try and submit applications without attempting mediation, it's knocked back straight away. So it's certainly mandatory. Second point is it's often beneficial to resolve things other than through court. There's different options out there. I think mediation is heavily pushed these days and people tend to know about it. A good solicitor worth their salt will always encourage negotiation and mediation first and court proceedings last of all. I've been doing this job for 20 years. I'm a member of Resolution, which used to be called the Family Law Group, and they promote resolving matters in a constructive way, non-confrontational, and court as last resort, really. Sometimes you can't avoid court if parties are entrenched or the difficult issues, but usually negotiation should be the first port of call. I would say 90% of the work I do is negotiation rather than litigation, which will probably surprise people because I think the public's view of solicitors tends to be you're always in court and you're issuing proceedings every day. Well, we're not. That's reality. So ADR, I've always promoted that, and I can understand why the courts favour it.
So you mentioned mediation as one option, but what other ADR options are available, and when may they help?
Yeah, so one thing that's become more common in recent years, I would say since COVID, is the concept of private FDRs, which stands for financial dispute resolution hearings. Pre-COVID, if parties went to court to settle their finances, frequently go to a second hearing. It was rare to settle at the first one. You'd be waiting maybe 3 to 6 months to be before a judge. The other, the private FDR, is rather than wait for a judicial appointment, You select your own judge, which could be a barrister, a solicitor, an arbitrator, who will effectively give a view as to how matters should settle and help you reach that conclusion. So it's mirroring the court process in a private capacity. It could be at a barrister's office. It could be, a service office somewhere which is more neutral, where the parties choose.
Great. If court is unavoidable ultimately, are there any ways that families can reduce the delay and cost associated with the backlog?
Yeah, I would say, take advice, and that perhaps sounds like a daft things to say, but many people have got a very entrenched view as to what to expect. What we need to always say to clients is, look, I hear your side of the story, I understand what your views are, but this is how a court is going to view it. You need an open mind, you need to be prepared to compromise and negotiate. That's clearly a key thing.
Great. And looking ahead, what changes would help the family court system, move quicker, do you feel?
My personal view is to have more video and telephone hearings. So pre-COVID, I never ever never had a telephone hearing for family law cases. It was always a case of going to court and waiting your turn. Typically, you'd have a case list for 10 o'clock. You get there at 9 o'clock. You'd be there till 3, 4 o'clock. There were always delays. It was very rare you'd be seen on the dot at 10 o'clock. Video hearings, telephone hearings tend to be a lot more punctual, certainly in my experience. If you're listed at 10, you're on screen or on the phone at 10 o'clock and you're done by 11. So you're literally saving hours worth of court time. For clients, it avoids stress as well. Most clients find it easier to attend court remotely by their home office or a workplace, as opposed to going to a physical court building. So that's a big efficiency, and I think it helps avoid on stress and cost as well to clients.
Thank you, Stuart. If you're worried about delays in the family court or want to explore mediation or a private FDR, the family law team at Mander Hadley can help choose the right route for you and your family. So please feel free to reach out to us and get in touch. Details will appear on screen shortly.
Thank you.
Thank you.